Medical malpractice is basically an allegation that the doctor or medical professional breached the standard of duty of care. I've had clients come in and say, I've had a wrongful or diagnosis of cancer where it wasn't diagnosed for an extended period of time, and by the time they found it, it was too late. I've had them where surgery's done and a sponge might have been left inside the patient, and then they had to remove it later on. I've had one where a spool of wire was left inside and subsequently was poking out a different part of his body later in the year. It was pretty bad. So we all kind of hear it. We get the comment thrown around a lot about medical malpractice. My doctor committed malpractice, the emergency room committed malpractice, and it's a pretty strong statement. Malpractice is basically saying the person didn't do their job the way they should have, the way other professionals in that field should have handled it, and that it caused you damages. We have a duty risk analysis in Louisiana when we look at these types of claims, any type of tort claim, and it's liability, causation, and damages are the three things you're looking for in any tort suit in Louisiana. So in a medical malpractice case, it's an instance where you're saying someone breached their duty of standard of care. The doctor messed up, the nurse messed up, the hospital messed up, and that mess up caused you to have damages. If it's a simple, the doctor gave me an extra stitch, yes, you might have a breach of the standard of care, but what are your damages? Something that healed in 5 minutes, that damage isn't really worth anything. So the ideal case would have high damages, liability is a cinch, and the causation is a cinch. But back to procedures, you make a medical malpractice claim. To do that, in Louisiana, if you are going to allege someone breached this duty of care, you have to file a complaint with the state first and say, I'd like to log a medical malpractice claim against this doctor. They're going to check, the state is going to then check, it's an administrative agency that's going to check and see if this doctor is covered under the patient's compensation fund. And basically, it's an administrative remedy. If you want to get to the point where you're going to sue your doctor, medical provider, whoever for malpractice, you have to first go through this written process. Then you'll be put in front of and have to go before what's called a medical review panel. It's a panel of at least 3 doctors in the similar field, or nurses or whoever. And those 3 doctors are almost like an expert panel that are gonna go through your submission, my submission I would do on your behalf, basically saying, here's the facts of what happened, here's why this person was injured, and their job is to render an opinion as to whether or not this doctor or medical professional breached the standard of care. That's all they're there to determine. In 13 years of practice, I've won 2. And I can brag about that, because you don't win medical review panels. You have to find doctors who are going to basically stand there and tell you that another doctor was wrong legally. And here's 2 things. 1, doctors don't become doctors because they like the legal field. 2, most doctors I know don't want to tell on another doctor. It's hard to ask someone to do that. So normally if you win one of these, it's rare. It's a very rare occasion. However, when you do, now I have an expert opinion that says this person, doctor, hospital, whomever, breached the standard of care. Now I can file suit and go to court with this panel's opinion as part of my evidence. And the burden is now on the defendants or the doctors to find an expert or opinion to disprove what this panel thinks. All of that is just to determine if they were at fault. Then you have to say, how much is the claim worth? Well, that's another story. Medical malpractice, we're dealing with people's lives. He cut off the right leg instead of the left leg. How much is that worth to you? It could be someone's mistake might have caused someone to die. It could be anything. However, Louisiana, most you can get is $500,000. Cut it off. That's the most your life is worth in Louisiana for a medical malpractice case. $500,000. Louisiana set that cap because doctors were complaining that their medical malpractice insurance rates were too high. whole other story that we can get into where studies are done. But basically, if you want to allege someone committed a medical malpractice, or there was some type of medical malpractice committed, you're looking at a long and expensive road. This medical review panel, these 3 doctors, they need to get paid. This filing fees need to be paid. There are, again, deadlines. Louisiana says you have 1 year to file for a tort action like this. However, there is a 3-year preemptive period. Now, what that means for medical malpractice claims is you need to file suit or make the claim within 1 year of the date of the alleged malpractice. Say a doctor does a surgery on me and accidentally leaves some debris inside. And I'm going about my life thinking the surgery was a success. 2 years go by, 3 years go by, and I'm starting to have abdominal pain. I go to the doctor, they open me up, and they find a sponge. They find something that was left in there from a surgery 3 years ago. You would then have, normally, 1 year to file suit from the date you found this. However, since it's been 3, you're out. Nothing you can do. That's preemptive period. So the bottom line is, for medical malpractice cases, there's a lot of deadlines, there's a lot of hoops that need to be jumped through. So they're not thrown around as wild as many people think. If a lawyer's taking a medical malpractice case, he's or she is probably investing some money in that. It's probably more to it. And the way we are positioned, I guess, today in the state is we protect the doctors, it seems. You know, there's so many hoops to jump through to prove medical malpractice. There's a cap on the most you can recover in a medical malpractice. And it's outright. The reason is because the medical malpractice insurance rates were too high. So again, the insurance company is setting the rates, which is causing us to have a cap on what the state views our possible injuries are worth. I think it's preposterous. I think they make it way too difficult to prove these, and I think the medical review panels are almost pointless. In almost any other case, I would have to have an expert opinion to attribute the damages to that action. So what is the difference here, other than hiring 3 experts who are going to get up and 9 times out of 10 tell me the doctor did not breach the standard of care? I mean, some of the ones that I've lost medical review panels on have been outrageous. But again, it's an industry that is not out to eat their young like attorneys are. So that's your medical review panels. That's your medical malpractice.